Steve Hart. I am the vice mayor. I'm going to be conducting the meeting this morning in the absence of Mayor Lake, who will be attending the meeting via the magic of Zoom from, I think, California. First of all, this is the special meeting of the City Council on May 26, 2021. It's 10:01 a.m. And the first order of business will be a roll call. City Manager, would you call the roll, please?
Mayor Karen Lake, are you present?
Yes.
Vice Mayor Hart?
Yes.
Councilman Bobby Brown?
Yes.
Councilman Tony Brown?
Here.
Councilwoman Kelly?
Yes.
Mr. Vice Mayor, we have a quorum present and Mayor Lake is attending virtually.
Thank you. Do we have any public comment cards?
I have none at this time.
All right, let's move to item number 2 on the agenda, potential intervention in litigation. The next step, as I understand it, is to view a presentation that you have prepared. Is that right, City Manager?
This was a presentation presented to the Clay County Board of County Commissioners last night, given by both St. Johns River Water Management District and Clay County Utility Authority. As opposed to making them repeat themselves this morning, I figured that we would just go ahead and watch what was presented. You also have their slide deck in front of you.
Thank you. Let's proceed.
This is where we discuss Lake Brooklyn and Lake Geneva MFLs. I'd like to, if I could, get Mr. Register up from St. John's Water Management, and then he'll be followed by Mr. Johnson from Clay County Utility Authority.
Do you have a clicker? Good afternoon, Mr. Chairman, Commissioners. I'm Mike Register, Director of the Division of Water Supply Planning and Assessment for the St. Johns River Water Management District. I'd like to start off by thanking Jeremy and Paul and everybody at the Clay County Utility Authority for all the hard work they've done over the years in collaborating with us on this MFL. It's unfortunate we haven't quite reached a meeting of the minds, but I am hopeful that through continued collaboration and work that we'll be able to get there. I'm here today to provide some background information on the proposed revised levels, minimum levels, or MFLs for Lakes Brooklyn and Geneva. After our governing board approved the revised MFLs and the associated recovery strategy in April, the North Florida Utility Coordinating Group, including Clay County Utility Authority, filed petitions challenging the existing MFLs for the lakes and the recently approved recovery strategy. And we also expect to receive a petition on the proposed MFLs in the near future.
Could I stop you for just a second? Can you explain to everybody what a MFL is?
Yes.
And why it's important?
Yep, well, I have that here in the presentation. We'll get to it in just a second. First of all, I'm sure everybody here is familiar with where they are. With Lakes Brooklyn and Geneva, located in Clay and Bradford counties, adjacent to the city of Keystone Heights. And it's shown here on the map that it's within the North Florida Regional Water Supply Planning Region. And here is slightly zoomed in. These lakes are a part of a chain of lakes in the upper Etnai Creek Basin, and they're sandhill lakes that are well connected to the upper Florida aquifer, and they are now, with all this work, among the most studied lakes in our district. Minimum levels for Lakes Brooklyn and Geneva were originally adopted in January of 1996, but were done so without the benefit of either a ground or surface water model. After models were developed to allow for assessment of these levels, concerns were raised with the levels and the district committed to a reevaluation of these MFLs. After working on this for many, many years, the district completed the reevaluation of the minimum levels for Lakes Brooklyn and Geneva in 2020. And as you requested, to talk a little bit about background on minimum flows and levels, the water management districts are directed by statute to establish minimum flows and levels that set the limit at which further withdrawals would be significantly harmful to the water resources or ecology of the area.
Now that's a withdrawal directly from the lake?
No, it could be any kind of water withdrawals, whether it's from the Floridan aquifer, which can affect the lake, especially in these lakes that are highly connected to the Floridan aquifer, where a change in the aquifer can actually affect a change within the lake itself. So it can be a direct withdrawal.
The aquifer extends all the way to Jacksonville, right?
All the way up. Our groundwater model actually extends all the way up to South Carolina. So it's a
Somebody in
huge,
South Carolina turns on a tap, you're sucking water out of one of these lakes.
well, I don't know if it would reach that far, but within that model domain, we wanted to cover as much of the Florida aquifer as we could so that we could make sure that we were looking at who's responsible for what part of the impacts to the lakes and not hold anybody accountable for other impacts that weren't being modeled in previous models and estimations. When we establish these limits pursuant to the Water Resource Implementation Rule in the Florida statute, districts must consider non-consumptive uses and other environmental values. These 10 water resource values that must be considered are shown here on the slide, and they do include recreation in and on the water and also aesthetic and scenic attributes of the water body. The models and methods used to develop the proposed minimum levels for these lakes went through independent scientific peer review, where they were reviewed by independent outside consulting firms. Input was also sought from the Florida Fish and Wildlife Conservation Commission, all of whom were supportive of the approach used. Interested stakeholder groups like the North Florida Utility Coordinating Group and the Save Our Lakes organization were also consulted throughout the process. These are just a listing of some of the more formal meetings and workshops that occurred over the last year, but there have been many, many others throughout the years. This has been worked on for about a decade now. The final criteria and analysis used for the development of the recommended MFLs and recovery strategy incorporated stakeholder and peer review comments and recommendations. And some of the most recent changes to the recovery strategy were as a direct result of comments received by those stakeholders, or from those stakeholders. After an exhaustive investigation of appropriate criteria, these are the final recommended criteria for the minimum levels for the lakes, which protect the relevant water resource values for these lakes. The open water metric was the most restrictive of the criteria evaluated. While it has been suggested by some that this is only an aesthetic and recreational metric, this metric actually provides protection of habitats not afforded by the other near-shore metrics, including deep habitats that large fish use as thermal refuge to escape predators and for resting. Some game species spend the majority of their time in this deep habitat, and the use of near-shore metrics alone would not provide sufficient protection for these species. However, this metric also ensures adequate protection of the recreational values provided by the open water area. This slide shows the results of the current status assessment, which again is a comparison of current pumping condition with the minimum levels conditions for each of the metrics. Positive numbers here mean that more pumping could occur before the criteria would no longer be met. Negative numbers mean that the criteria is already not being met. As I mentioned, the most constraining metric for the lakes is the open water area metric. But as you can see, several other metrics are already not being met or are close to not being met. Therefore, Lakes Brooklyn and Geneva are considered to be in recovery, and a recovery strategy had to be developed to recover these lakes so that they meet the recommended minimum levels. As a part of the rule development process for the MFLs, stakeholders have the opportunity to propose lower cost regulatory alternatives to the rule that substantially accomplish the purpose of that rule. The North Florida Utility Coordinating Group collectively and JEA, Gainesville Regional Utilities, and Clay County Utility Authority individually proposed an alternative that is equivalent to the minimum frequent high as shown on the first row of the table, the least restrictive criteria while ignoring the other metrics. This alternative proposed on the behalf of the utilities would allow the median water level in the lake to be lowered by more than 14 feet, effectively turning it into a wet prairie. The district does not believe that this accomplishes the objective of the MFL statute, and therefore this, along with the other two recommendations, were rejected during the public hearing last month at our board meeting. I do want to say that I appreciate collaboration from the staff at the Clay County Utility Authority and the other members of the North Florida Utility Group, and look forward to hopefully continuing to work with them to implement this recovery strategy to recover these lakes. That concludes my presentation.
Thank you, Mr. Registrar. I'd just like to point out to my fellow commissioners that that picture is not a lake. Just in case anyone had any questions, that's a grass prairie.
Any questions for Mr. Register at this time? Commissioner, did you get the answer you were looking for on the MFLs? Need him to go into more detail on that?
Well, I've
just
looked
wanna
at
make
it,
sure.
I'm just trying to get the public to understand what they're talking
I
about
understand.
when they're talking about MFLs. I mean, I don't know if that was enough, or even if it can be done, but.
Mr. Register, could you speak to the recharge areas for the Florida Aquifer?
Well, there are several recharge, a lot of Florida is recharge areas, but the most significant available recharge area is this Lake Brooklyn and Geneva area. It's it's at the high point of the groundwater mounding in the area, and so it's an ideal spot, which is why it was picked to be the location for the Black Creek Water Resource Development Project.
So the recharge of the Florida Aquifer depends on these lakes. So we're not just talking about restoring the aesthetics for Keystone Heights and game fishing and recreation and things like that, but it really is about restoring the Florida Aquifer recharge.
That's the purpose of the Water Resource Development Project, the Black Creek Project. An ancillary benefit of that is that it'll provide sufficient recharge to the area and also surface discharge to the lake system so that it will recover the MFL. So the important thing and something that people don't realize about minimum levels is it is not an ideal condition for the lake. It is the break point between when significant harm to the lake is going to occur if additional withdrawals occur, lowering the lake more than that. And so it's not an ideal recovery, but because this is an ideal site for providing recharge to the whole area as a part of the North Florida Regional Water Supply Plan, the ancillary benefit of that high recharge project would be to provide benefit to these lakes.
Thank you.
Any other questions at this time? No, sir. Thank you. All right. Let's get Jeremy Johnston up from Clay County Utility Authority. He also has a presentation for us this afternoon.
Good evening. Jeremy Johnston, Clay County Utility Authority. Let's make sure I operate this correctly. There we go. All right. Good evening. Thank you for having us, and we're happy to be here for this meeting to talk about a very important issue. There we go. All right. I wanted to set the table a little bit regarding CCUA's mission for the Clay County community. We're a special legislative district. We're a public utility whose mission centers on public health, safety, and general welfare. Central to that mission is delivering safe, reliable, and affordable drinking water to our customers here in Clay County. As part of that duty in delivering safe and reliable drinking water, we do have a fiduciary duty to our customers. As our legal counsel will tell me repeatedly when we're setting budgets, we have a dual rational nexus that we have to meet in how we set our rates, fees, and charges. That means that those charges, those rates and fees and charges have to be tied to the actual cost that it requires to deliver service to our customers. And we're using the same principle in navigating the discussions with the district. To tie the discussions with the district with what the water demand and related impacts are. CCUA has a long history of environmental responsibility. This is tied to the environmental and economic sustainability all of you have heard me talk about. Our previous executive director led the way in the reclaimed water system well before it was ever needed. And this county has reaped the benefits of CCUA's investments in like the TMDLs, which ended up being an $8 million investment for CCUA, and it offset the potential investments of $20 to $25 million in capital infrastructure on the stormwater side. So clearly we've been very active on the environmental and economic sustainability for the overall welfare of Clay County. I also want to say we're committed to continuing to work with our partners, both now and into the future. And I also want to recognize the Water Management District staff. They're the utmost professionals in what they do. They clearly have a public mission, and we respect the work that they do, and we do want to continue to work in the most positive fashion to resolve these issues to everyone's benefit in the community. Some starting points. As Mike has pointed out, the Lakes Brooklyn and Geneva are sandhill lakes. There is a significant amount of variability in those lakes. Water demand from people using the Floridan aquifer does affect the aquifer, does affect the lakes, as Mike has pointed out. We've always acknowledged that, and that's part of the alternative water supply initiative, the reclaimed water efforts, et cetera, is to take water off of the aquifer to other particular sources. The Water Management District is developing a great project, the Black Creek project, that would take water from Black Creek up to the Keystone Heights Lakes to address lake levels as well as the MFLs and impacts to the aquifer. I have been very public in my support of the Black Creek project. I continue to support the Black Creek project, and I think all of you have had a memo that I gave to my Board of Supervisors addressing this issue, and I did recommend participating to support this particular project. The information we currently have, and this may have changed, but what we currently have is that there's a funding shortfall for the overall financing of this project over a fairly long 20 to 25-year window. Some events, timeline of events. Yes, the MFLs have certainly been a topic of discussion and development for a sustained period of time. One of the things that has led to these particular issues, before I get to that, we saw this coming. We did engage the Reese Engineering team last November for planning efforts that were not only tied to this, but also the zero surface water discharge requirements. Now, jumping to recent events, CCUA was first approached by the district on March 23rd regarding financial participation in the Black Creek project. My next board meeting wasn't until April 6th, which on April 6th we did see a third revised recovery strategy that was sent to us. And so I do have a duty to update our board regarding financial obligations and commitments that we would recommend to participate. And between March 23rd and April 6th, we were actively evaluating what the proposal was, the potential impacts, et cetera, but there wasn't enough time to fully evaluate that. Shortly thereafter, April 8th, the utility coordination group members, which was the ones that participated were JEA, GRU, St. Johns County, and CCUA. We submitted a letter to the district requesting more time to work these issues out. The board meeting, the St. Johns River Water Management District governing board meeting on April 13th did set a number of timelines in motion, of which we would be required to file petitions if we were to protect our customers' rights. And that is in large part where our focus is protecting our customer rights, that fiduciary duty. On April 20th, I took a memo that I think all of you have to our Board of Supervisors requesting authorization to negotiate with the Water Management District. And if those negotiations did not bear fruit, then I was authorized to file petitions to protect those legal rights. And the objective of those petitions was defined in that memorandum to seek a solution to the MFLs as well as participation in the Black Creek project. Since that time, the petitions have been filed. On April 22nd and 28th, the members of the Utility Coordination Group and the Water Management District met twice. The utility groups did put 2 financial offers on the table, trying to find a solution to this. We had a set methodology calculating impacts, costs of projects, et cetera, as we understood the situation, and we offered those to the district. With the second offer, there was terms and conditions that were presented, and we are currently working through some communications to hopefully address that. Further, the last communication, formal communication with the Water Management District was just this last Friday, where our legal counsel did send a letter to the Water Management District, again seeking to have a meeting to resolve these particular issues. And further, we had prepared, the legal team had prepared a draft participation agreement to the district to consider that had terms and conditions, et cetera. And so we're hopeful that those communications, those meetings will be fruitful. And I believe there is a meeting coming up on Thursday to help resolve this particular issue. So CCUA, I think the entire utility group that's involved is hopeful to resolve this particular issue. One of the things that's important, and you heard me talk earlier about our fiduciary duty, the impacts to the lakes in Keystone Heights, there are a lot of water users that impact those lakes. This is information from data from the Water Management District that our legal and technical team put together. This represents the entire area that is contributing impacts to the lakes. And CCUA acknowledges the impacts that CCUA customers have. We have a duty to address those impacts. But CCUA, what we're struggling with is, we do not see where we necessarily have a duty that's outside of what those customer impacts are. So we're being very diligent to tie our proportional share of participation to what our customer impacts are. This is a representation, again, prepared by our legal and technical team, giving a representation of lake lift from the 2045 projected lake level up to the MFL recovery as they calculate it. That's the 3.9 feet of lift. Of that, you see CCUA's proportional ratio of that of a 0.49 feet lift, and I believe that's at a 25 or 28 MGD water demand, as we are trying to look forward to make sure we have adequate water supply allocation for the future. The Black Creek project goes well above and beyond the MFL with a lake lift of about 9.9 feet as we understand it. And again, CCUA's proportional 0.9 feet is related to the entire Black Creek project. Again, we think this is a great project. I've said repeatedly we want to participate in this project so long as that participation is proportionally related to what our CCUA customer impacts are. From our perspective, the MFL on its own does have challenges because, again, from our planning effort, CCUA does not see a path forward for CCUA based upon information without participating in the Black Creek project. That's why they're so intertwined, is to meet the MFL, the participation in the Black Creek project is essential and desirable because when you look at the cost of other options, they are exceedingly expensive and would bear a significant economic impact to Clay County and our customers. And again, speaking in support, the Black Creek project is an innovative project. It addresses the MFL, the recovery of lakes, and the long-term water supply planning for the North Florida region, which is obviously a tremendous value proposition for the utilities, CCUA, and I've spoken to our board at that April 20th board meeting that was a significant value proposition for the utilities. So summing it up, we continue our efforts to engage the district. We're looking forward to continued discussions. We want to find a solution to this issue. We are prepared and we want to participate in the Black Creek project, but again, tying it back to what our customer impacts actually are. And so with that, I can answer any questions.
Commissioner Conley, you have any?
I believe that concludes the presentation. I have some questions of legal counsel. Our agenda indicates a potential intervention in litigation, but there's no litigation pending as such. Is that correct?
Well, the petition is litigation. the petition, the challenge is considered litigation. It's not in the court system in the traditional sense.
Well, that's my question. It's still at the administrative level, is that correct?
Correct. But that is considered litigation.
Okay, just wanted to clarify that. I think how I'd like to proceed is basically ask for comments from council. Mayor Lake, are you still on board?
Yes, I'm here.
Do you have any comments or questions?
I don't know who's in the room, but I'm wondering if Vivian Katz James is there. Is she there?
Yes.
Would she be able to come to the microphone and let me know what Solo would prefer the city to do? I'd like to get some input from some other organizations.
Miss Vivian, if you can just wait for 1 second, please. I apologize. Mayor Lake, we do have representation from both CCUA and St. John's River Water Management District, as well as Save Our Lakes in the room for questions from council.
Vivian, would you state your name and address, please?
Vivian Cash James, 6579 Monthly Road, Keystone.
Good. And what comments do you have?
I think there's for Solo and for me, there's a little confusion, and you just brought it up. Are we legal yet, or are we still administrative? And Solo is in a position that I believe that if we're going to file something in support of the water district, which I say totally we should do, I think we should be a united front. That's been some of our problem in the past years. So if we're going to file, city file, Solo file, and LRDC file, everybody file, so that we're all saying the same thing to the water district, letting them know that we're supporting this, and to the utilities so that they understand that we have a position here. I think one of the problems with the utilities, I think you can hear that they all want the Black Creek project. It literally is down to dollars and cents. And I'm sorry that you didn't get the last few minutes after that session, because Commissioner Condon asked some very specific questions, and she might want to ask those again so that you can get some response from the utilities. But what I think is not being acknowledged is they've got to pay a price now for future use and for future growth. What they don't understand is the price that we have paid for the past 3 or 4 decades. So we've already paid a huge price. And so whatever they need to pay now, even if it's a little bit more than they want to pay, it's time. It's time to go ahead and resolve that. So I don't know if the mayor or anybody has any questions for me. I'll be happy to sit down or answer whatever.
I think we do have some time constraints with the city attorney, so we'll try to keep this as short as possible, but as complete as possible. Does anybody have any questions of Vivian? Mr. Brown?
Could you elaborate? I'm sorry I did not make that meeting yesterday, but can you elaborate what happened at that meeting you attended yesterday?
And we can play that footage if you'd like, Vice Mayor Hart.
The JEA meeting?
Or no, I'm sorry, not the JEA, but the rest of the commission meeting.
Are you talking about the JEA, the JEA meeting? I think it went really, really well. You never know when you're staring at people what they're thinking. But the presentation by Mike Register was very good. I got to make a statement. So we kind of, Commissioner Condon came on and made a wonderful statement. So, and Webb Farber sent in an email, and they read it into the record. So everybody was pretty much saying the same thing. It's time. I will say that. So in a very public place, and people aren't going to say a lot. They're just going to acknowledge, thank you very much for your comments. That's kind of what they did. But the demeanor in the room seemed to be positive. I will say that I think it's the director, Jay, I didn't get his last name, but I think he's the director, new director, 6 months in, indicated that they were definitely wanting to negotiate. They did not really want to go, into litigation. So they were trying, like you just heard. I think they're all trying to negotiate, and they just have to get, and of course we don't know litigation, we don't know what those are, what's being said in the room. but I think all in all, we were accepted very well. We had quite a long conversation with the director of the environmental, does anybody have a name? Wayne Young, after the meeting downstairs in the lobby. Very, very positive conversation. He pretty much said he was very supportive of our situation and concerned about our situation, and it should have been resolved a long time ago. So I think we have some ears there for a change. I think if Solo had known we needed to do that, we probably would have had red shirts there a long time ago. But anyway, I think we're in a position to finally resolve things, and I think tomorrow is the day that we find out. And I will ask one quick question while I'm here, is as far as filing anything, how much time do we have? Do we have time to give them time to negotiate a little bit?
And Mr. Vice Mayor, in response to that, Ms. Winkler's here and can answer some of those questions if
Okay.
council's
Okay.
willing to.
Yeah, I'd like to know what the procedure is at this point, where we're at.
Okay, thank you.
Thank you,
And also,
Vivian.
if Ms. Winkler can also address, there seems to be some kind of confusion as to what the term litigation means.
Sure. Good morning. I'm Mary Ellen Winkler. I'm General Counsel for the St. Johns River Water Management District. Thank you for inviting me today. Where we are in terms of the litigation is a petition for administrative hearing has been filed on both our existing, as Mike mentioned, we have an existing MFL. That has been challenged, so a petition for administrative hearing has been filed on that. We've also received a petition for administrative hearing on the recovery strategy. So there's actually two. We expect a third petition for administrative hearing by Tuesday, June the 1st. That's the deadline to challenge the proposed rule. Those, so far, the two that have been filed have been consolidated into one case, and that case is pending over in Tallahassee at the Division of Administrative Hearings. Because we are an administrative agency, all of our litigation generally happens before the Division of Administrative Hearings when we have permit challenges or we're in a rulemaking process or a lawmaking process. So all of those types of challenges in litigation are heard over at the Division of Administrative Hearings in Tallahassee. I guess second question is what are the timeframes to challenge or to intervene? Typically, the rule states that you have to intervene at a minimum of 20 days before the trial starts. We do not have a trial date yet. We anticipate that the judge will set a trial. The parties are supposed to get together and decide on their availability for trial. We make a suggestion to the judge about when everybody's available. And then we anticipate that response is due June the 4th. And we expect that the judge will decide when the trial will occur June the 7th. Best guess right now would be July timeframe, mid-July, possibly into August. So you've got to intervene 20 days ahead of that. So you probably have until very early June to make a decision where things stand now.
If this goes to trial, would the aggrieved party, the losing party, then have recourse to the court system?
They would. Any of the orders, when the judge would issue a final order on the rule, that order can be challenged to the appellate court. So it would then go to a district court of appeal.
So procedurally, what the utilities are doing is exhausting their administrative remedies as a precondition to bringing suit, should that occur and should negotiations fail.
Yeah, this is how to challenge a rule. So the administrative process is how you do it, and then from there, it would go to a district court of appeal. The rulemaking proceedings are not held in what the typical circuit court, county court. We are administrative hearing process, but we do share and do go to the same courts of appeal.
So in making our decision as to whether or not to get involved, we would have a second kick at the cat should that occur.
You would, so in terms of presentation of evidence and things of that nature, this is it.
Okay.
You would certainly, if we were on appeal, you can file what's called an amicus brief if you would like. But in terms of having a say in front of a judge who's going to be, in this case, a fact finder and a decision maker in terms of this rule, and have we done enough? Is there enough scientific evidence to support the rule? This is the time. But certainly on appeal, on occasion, people do file amicus briefs. That is another, but it's really, at that point, the facts are set, the science is set. The District Court of Appeal would only at that time be discussing things related to interpretations of the law.
So this is basically going directly from the administrative process to the DCA without
Right.
an intervening trial court.
Right. Essentially, in this case, the DOA, Division of Administrative Hearings, is the trial court.
I see.
Yeah.
Does anybody in the council have any questions of council?
So
Yes, sir.
the utility companies that we are involved in this, is Clay Utilities, JEA, and is there any others that
So
are?
right now, the challengers are Gainesville Regional Utilities, Clay County Utility Authority, Jacksonville, JEA, and then there's a coordinating group of utilities, the North Florida Utility Coordinating Group, that is also comprised of 8 utilities that is also challenging. And that collective also includes JEA, GRU, and CCUA. So we've got a collective that's sued, and then 3 individual utilities.
And their biggest argument is the MFLs. It seems like everybody's okay. Clay Utilities have said that they're okay with the Black Creek project.
So there's 2 different things going on. One is certainly what we're hearing, at least as we've gone to these meetings, is that it doesn't sound like there's a lot of complaint about the science in the MFL. It sounds like that there is more concern about the how to recover it. And so I think this is a situation clearly where the parties are challenging everything, and they can do that in order to hopefully get a result that is more satisfactory to them and their ratepayers, I think, is where they're at. So, so it's one of those things in terms of legal strategy. People can challenge, it's what they do, and we have that. They challenge everything and hope to work something out that they like.
There are no stipulations at this point. It's still in the talking
No,
stage.
we are having a meeting tomorrow and continuing to talk with them.
Okay.
You said recovering. They're trying to figure out how to recover, or what are they recovering? The finance part
So
of it, or
what we call when the minimum flow or the water level is not being met, we call that the water body is in recovery. So in this case, we have a recovery strategy. And in, that is one of the things that they've challenged. Our board is required by statute when we set an MFL, if that MFL is not being achieved, or there's a prediction that we don't think it'll be achieved within a 20-year, that it might break within 20 years, we have to, at the same time that the rulemaking is done, we also have to adopt a strategy to fix it. They don't want us adopting rules without the fix with it. So in this case, that's what we've done, and it sounds like a lot of the issue is with the recovery strategy, how to pay to fix it, how to do that. So that's really, I think, the crux of the issue right now.
It seems that we are somewhat united in interest with the water district, and to us get involved with the litigation at this point might be overkill. However, if we might have the opportunity, in case things aren't going the way we want them to file a brief amicus with the court's permission, that perhaps might be the correct way to proceed, because of the cost of the taxpayer dollars and so on in getting involved in litigation. I'm not asking for your legal opinion. You're shaking your head yes. So am I.
It's really, it's up to the community. Certainly, we've had cases like this. We litigated when we did the Silver Springs MFL down in the Ocala area. That was a controversial MFL. We had local government intervened in support. I believe it was Ocala and Marion County both intervened and supported that. They didn't actively, as an intervener, it's up to you how active you want to be in terms of the litigation. So if you want to intervene so you can have a say in what your views are, you can certainly do that. Some people, interveners might present evidence, others may not. So intervention in terms of how active you are in the case is really up to you.
Just as a preliminary thing, I did file a short memo with the city, and of course we'll make copies available. Just based on my research, and my conclusion is we would have standing to intervene. I don't think that would ever be an issue, or could be an issue, because of the duty of the utilities to the public, affected with a public interest, and we are a member of the public, where we represent the public. So I think we have good standing to get involved, should we choose to do so. But that'll be up to the council
You have to
decide.
certainly, yeah. When you file your motion to intervene, that you would certainly have to demonstrate that. Absolutely, right.
Okay, all right. Any other questions of council? Thank you very much.
Thank you, sir.
Appreciate
Thank
it.
you.
Thank you.
Do we have a representative from the utilities who'd like to say something?
I could just respond to any questions.
Certainly. Why don't you come to the podium, tell us who you are, and we'll see if there are any questions.
Hi, my name is Celeste Goldberg, and I'm with Clay County Utility Authority, and I can
Okay.
answer any questions you might have.
Okay. Does anyone in the council have any questions? Mr. Brown, Tony Brown.
Okay. We've been beating this dog for, like Vivian said, 30 years or more. My concern, and I will give you an attaboy for your utilities. I mean, I love what they have done to Keystone in the way of bringing service, inside the city limits and outside the city limits, and working with businesses and everything. But my concern is, I can't see as a taxpayer, not just a city councilman, but as a taxpayer, how any utility in this community can fight something like this, because I look at the growth is going up on the other side of 16 and 21, out where Rosemary, the dump is. Out there, all those old farmland is all houses now. We've got to have water, and we've got to restore these lakes down here for the aquifer, for people in that north end, and not just here, but just around our area. And it's not just about putting a ski boat out on the lake anymore. It's to restore our aquifer, and the only way you're going to do that is to everybody come together. And I understand you guys have a job to do, but the litigation and all that stuff, I think that's a waste of time. I think we ought to just get together and work on it and say, I pay my water bill. I don't have a problem paying a little bit more every month for my water so that we can have water 20 years down the road. That's the biggest concern I've got. I probably got another good 20 years here, but I'd like to see not just water in Lake Brooklyn and Lake Geneva for boats and fishing, but for that I know that my kids and grandkids and other people's families are going to have water to drink. And that's one of the biggest concerns. I mean, I don't have degrees or anything like that like you guys have, and I don't understand all this stuff, but I do know we got to have water. And I would hope that your utilities and all the utilities will come together and work with St. John's Water Management. We don't have to go to court. But as a councilman, it's my duty to say, I'm ready to fight. I'm ready to put the money in there so we can go to court if we have to. So, but on the other hand, I do appreciate what y'all do for Keystone.
If I understand the presentation correctly, the focus of the utilities is on your fiduciary duty to your ratepayers. Is that a fair summary?
We do have to make sure that, and it's the same thing, you're a ratepayer, and that is part of this. We do have people in Keystone who are ratepayers to Clay County Utility Authority. These are individuals that are not on wells. And we have a responsibility that if we put an additional charge on your bill for a particular project, like participation in this, we have to be able to look each of those customers in the eye and justify that we did our due diligence, that they're responsible for this particular charge, and here's the why behind that, here's how we got there. So that is what we're trying to do. It has not been the goal of the utilities from the beginning to get involved in a litigation. This is not something that any of us want to do. Our goal is to work with the district to try to come up with a solution, to be able to have where all parties feel like the MFLs, this is something that we can work with. And the same thing with the Black Creek project. We have consistently all along, numerous public meetings, said that we are in support of the Black Creek project. We want to participate in the project, but just like the graphic that you saw that shows what our percent that we believe the customers have a responsibility for what their usage is on the aquifer, that has to align with what we're charged for participation in the project. And we have provided 2 draft agreements so far to the district requesting participation and some terms and conditions with that. We provided some updated information to them on last Friday, the 21st, with a draft participation agreement and revised petitions related to this matter that we think kind of makes the position a little bit more palatable for all parties. And as was mentioned earlier, we do have a meeting scheduled with the district tomorrow that we are hopeful that we'll be able to make some type of resolution in the right direction. And I believe that's been the goal of everybody. And, you know, part of the thing of recognizing as well is just like you've mentioned with growth for Keystone and surrounding areas, we have to make sure that what the allocations are that we can use of water is going to meet our current supply and come up with some type of standards so that we can accommodate future as well. And when we agree to participate in a project, we need to know what it is that we're financially, I don't know if that buying is the correct word, but what we are actually agreeing to. What are we getting in return for this that we can tell the customers, yes, this is actually what this is securing. This is securing water use up to this point or this particular quantity. So we have to be able to have those answers. And one of the questions that was mentioned earlier is that how much this would mean in a dollar charge or, you know, financial charge per customer to participate in this project. And we don't have the answer to that yet. And that's not trying to be evasive in an answer. We're not going to know what that dollar amount is until we know what the final amount is that we would pay to participate based on negotiations. And then whatever that dollar amount is, we would have to look at the financing terms. How long would we try to finance this money for? And then that, you know, comes with a cost as well. So we would have to work out all of those moving parts and pieces to be able to come back and say, this would be a specific amount.
I think generally the answer to my question is yes, you're looking out for the ratepayers primarily. Is that a fair summary?
Absolutely.
Okay. You're probably familiar with Chapter 366 of the Florida statutes regarding the public utilities, and just a general statement, the preamble, the regulation of public utilities is defined herein, is declared to be in the public interest, and that's a continuation of old common law where regulated monopolies are declared to be involved with the public interest if in fact they are, and our argument could be that we are the public, and perhaps the utilities might consider a little more heavily the interests of the public. Also, the Florida Constitution does say it shall be the policy of the state to conserve and protect its natural resources. And if you have time, there's a very interesting Florida Law Review article, you perhaps are familiar with it. It was done in 2009, that gives the history of water law in Florida all the way up to the present and balancing of the various interests. And that's really what we're talking about here, is balancing of interests. But I would encourage the utilities to take the people's interest, not just in Keystone, but generally, and not just focus on rates, what you're going to charge to put a pipe under a road, that sort of thing, but consider our needs as well. Okay. Are there any further questions or comments from Mr. Brown?
Would you have any other sources of recovery, like besides tacking a surcharge or something like that per customer? Any federal monies, anything that you could tap into to help recover some of the output?
That's not something that I can answer as far as without really researching into how would we go about it as a utility.
Right, but it probably would be possible, you think?
I'm not sure.
I do appreciate everything you guys do, the water pressures at the fire hydrants and everything. That's keeping a lot of people safer, but that's all.
Any further questions? Mayor Lake, are you still on board? Apparently not. Okay.
Well,
I would like to echo Councilman Brown's comments in that I sincerely hope that all of the parties involved continue to negotiate and mediate their differences. I also feel strongly that I want to support the Water Management District in its efforts to recover our lakes, and I'm supportive of intervention.
Thank you. Any other comments or questions? Thank you.
Vice Mayor Hart, if I may.
Yes.
There was additional questions at the commission meeting last night regarding some of those very issues. I don't know if it's to your if it's your pleasure to go ahead and continue watching the commission meeting.
Yes, I'd like to.
Have any questions?
What is the per cents a month that we're talking about, the expectation of the users?
Well, it all depends on what the dollar amount is, the term of the financing, et cetera. There will be a cost recovery to that, whether that cost recovery is 5 years, 10 years, 15 years, 20 years gives you a different answer.
Right, but aren't we talking about a difference of anywhere between a quarter per month per user to 12 cents per month per user?
I have not had any calculations down to 12 cents, but this is not an astronomical amount. I agree with you, but again, we have a fiduciary duty of whatever that amount is, there has to be a rational nexus to what CCUA is actually paying for.
I just want the public to understand, we're not talking about large dollars in their water bills every month. They've enjoyed being able to pump that water essentially for free. I mean, you all charge for your services, but no one has paid the Lakes Brooklyn and Geneva for that water. And so now it's time that we have to go back and do the recovery, and we're not talking huge dollars per user per month. Correct?
It is not giant. If you're asking percentage of the bills, I don't have those in front of me, but I mean, you're not talking dollars per bill. No, you're not talking to those type of numbers. But again, there has to be some rational calculation for whatever that is, whether it's 25 cents, as you've noted, 50 cents, whatever, because obviously we have stakeholders. What am I getting on my bill? And we have to demonstrate there is a financial commitment, a financial reason, logical mathematical support for what that bill is, regardless of whatever it is.
Thank you.
Commissioner Renninger.
First of all, you're a member of Northeast Florida
Utility Coordination Group.
Are your sentiments that you expressed tonight, I know you can't speak for that consortium, but are they similar to the other sentiments of the utility companies?
I will say that we have great working relationships with all of the utilities in the North Florida Utility Coordination Group. We coordinate often, and I would say all of them that I've communicated with have expressed a similar sentiment of trying to find a solution. All of them that are engaged in this are going to be at Thursday's meeting. We are sharing counsel, et cetera. So there is a sincere desire to find a resolution.
So there's no outlier has some anomaly that they're trying to resolve? They're all the problems are similar from one utility?
Correct. We're all sharing the same methodology in how we calculate numbers.
Can you go back to that pie chart? I just want to understand something, if you can go back. And I'm concerned about the utility portion, and who are the other colors in that pie chart?
Let's see here, you have some just working
out of
around.
state?
Yes, I'll start with the blue. That is the public water supply, and the public water supply is more than just CCUA, JEA, GRU, and St. Johns County Utilities. Those are the big four, but there are other public utilities, public suppliers that would be in that pie chart. Others consumptive use permits within the water management district. I think that's 19.3%. And that may be industrial type users, commercial type users that have their own standalone CUPs, I believe. Out-of-state users, I believe this is in the state of Georgia. There's other various CUPs within, or other users within the district. That accounts for 9.8%. Local users, which I believe is the domestic self-supply that is around the lakes. I think it's a certain 10, 11, 12 miles, something like that. They have about a 10 to 11% impact on those lakes, and clearly users within the Suwannee River Water Management District would have an impact on the lakes.
That's one of the questions I need an answer to. When I sink a well, does it go down to the aquifer?
Yes, sir.
So anybody with a well is contributing to this problem?
It's a natural system, so any output from that system will have an influence to it. It could be very small, but even small influences, when you keep adding them up, can add up to a decent sized impact.
I live in Orange Park, and we have a utility system in Orange Park, so I don't have a well. But I've heard of people having a shallow well. Does that take surface water, not aquifer water?
Well, there is
a
a superficial aquifer that's near the surface, but it doesn't take you very long to generally get to the Floridan aquifer. The depths vary, obviously, because of topography, the hydraulic gradient, et cetera. But you don't have to go very deep. And from what I understand, most wells generally do end up touching in some aspect the Floridan aquifer.
So in general, just for simplicity's sake, if I have a home that's on a well system, you can probably a high probability that it's coming from the aquifer.
I would agree with that statement.
An artesian well, that is definitely coming from the aquifer.
Again, an artesian well that's essentially free-flowing just means the hydraulic gradient is such that it allows the water to flow without resistance.
That's probably 100%
That's probably
aquifer.
pretty good, yeah.
Anything else for Jeremy at this time? Go ahead, Commissioner Bola.
The slide where you had the level, the 9 feet.
Yes, sir.
Are we saying that this Black Creek project will raise those lakes 9 feet?
Yeah, that's the information we have from the Water Management District, that this project would raise those lake levels by 9.9 feet. That's our understanding.
And whose number is that? That's theirs?
That information is from the district. We were using the Water Management District models to calculate the proportional share of the 0.49 feet, as well as the 1.1 feet for the public suppliers. But that information, that raw model data, is from the Water Management District.
Well, that's different than what I was originally led to believe this would do. We're talking, what size pipe are we talking about now?
I don't recall off the top of my head of what size,
It was a 10-inch pipe when it started. I understand it was increased. What's the flow rate on a 10-inch pipe?
It depends on the pressure behind it.
How much
pressure do you have?
A 10-inch pipe, given the pressure, a certain pressure could certainly deliver a lot of water. But I think the project that the district, and the district's here to probably talk in detail about this.
7.5 MGD.
Yeah.
And then we're only going to run that when Black Creek floods?
There are operating parameters
I'm going to need you to come up. Yes, sir, Mark.
I needed answers to this question as well.
There are operating parameters to do with when the water will be taken from Black Creek. It'll only be taken at certain elevations. The project is designed to where it has the capacity to do 10 MGD when it's pumping, and looking at records of what the levels in that creek are and how much can be withdrawn. It would withdraw an average of 7.5 MGD on average is what is capable. Yes.
So I think somebody told me that it would only be, we'd be pumping at flood stage. That's not true then.
Well, Black Creek runs at a pretty high level, and that amount, even though it sounds like a lot, would only lower right around the intake valve like an inch or so. It's a very small effect on Black Creek with the amount of flow going through that section of Black Creek. So it's a very small impact of that. There are times if it got low enough that they wouldn't, the design would be so that it wouldn't pull from it, and that's why on average it would be about a 7.5 MGD.
But in general, it's going to be pumping every day, kind of. It's not at the flood level stage. It's, like I said, that's what I was told.
It would be pumping at the flood level stage. I don't have the specifics with me, and I'm not working on the design of that project, but we can get you more information on what the actual operating parameters are as far as when it turns on and when it would actually turn off. But because of the development in that area and a lot additional runoff, that creek flows at a higher elevation than it would naturally, and that's why they have a lot of the flooding impacts that they have in that area. And so this would take off, it would skim water off the top of those higher stages so that it's not noticeable by anybody, and allow it to be then beneficially used for recharge for the general area, and also benefit Brooklyn and Geneva.
How often does the Black Creek reach flood stage?
I don't have that information.
John Ward,
on me.
is he still here?
No.
The other question
We usually hear when it hits flood stage. I start getting calls, and
Vice Mayor Hart, this is about the end of that conversation. I did reach out to Clay County Emergency Management Director, Mr. John Ward, regarding that specific question, just so to my understanding. We continuously hear it over hurricane season that Black Creek is at a dangerous level, or it's at an active level, flood level. It's my understanding that there are 3 different flood levels for Black Creek, or any creek, lake of that matter, and then there's also an active level, and then a normal level or a below average level. The creek itself stays at an active level most of the time. It's not a dangerous level, it's not a flood level, but it is above its normal flow levels, if you will.
That's good information to have, and thank John Ward for that. I think the actual issue at hand, though, is whether or not we're going to intervene. Do either one of the direct parties in interest have a comment or question concerning the last portion of that presentation that we saw?
Yes, sir.
Would you like to speak? Okay.
Yes, sir.
No. State your name, please.
Thank you, Vice Mayor Hart, Scott Cornegay, Lake Region Development Corporation. Just a couple of things. First of all, the issue of the money, the portion of the cost that the utility is going to pass on to their customers. I think everybody pretty much understands that it's a small amount. We don't know if it's 12.5 cents. Jeremy said yesterday that he's not seen anything that would push it that low. He also said that he hadn't seen anything that would push it close to $1. So we're looking at somewhere between 12.5 cents and $1 per customer per month. Bear that in mind. Although it'll probably be slightly higher than you might think, because I'm sure they'll have to pass on the litigation costs to their customers as well. So that's something to think about. Also, not to speak on behalf of Solo, but I did talk with Vivian, and she said it was okay for me to share that both Solo and the Lake Region Development Corporation have retained legal counsel. So as Councilor Winkler pointed out, if you do decide to intervene and you file to intervene, you can still determine at what level you want to intervene at. So it's the position of the Lake Region Development Corporation that we would like to intervene and then gauge our level of intervention as things move forward.
Thank you.
Thank you.
Does anyone else have a comment concerning intervention, that narrow issue? We're not that concerned about Black Creek and so on at this point, but
Mike Register, Director of Water Supply Planning for the St. Johns River Water Management District. One of the things I wanted to clarify is that some statements have been made about what's been petitioned and what hasn't so far. And so far, just to make it clear, they petitioned the existing rule. So that's the existing MFL that's been on the books since 1996. And they've also filed a petition for the recovery strategy. They have until, I believe, next Tuesday to file a petition on the proposed rules. And so there's been some discussion, and there hadn't been a lot of discussion about whether or not they disagree with the science of it. I do feel like we're very close in agreement on what the effect is of the pumping and how much that pumping is going to affect the system with the modeling and that. The preview of what I anticipate we could see as a petition that would come on the proposed MFLs, the only thing I really have information-wise on that is what they proposed in their lower cost regulatory alternatives. And the first proposal on that was what was in my presentation, which is to not look at any of the metrics that we had come up with on it except for that minimum infrequent high, which is designed solely to protect uplands from encroaching down into the lake. And that's the one that would, if we adopted and took that lower cost alternative proposed by the North Florida Utility Coordinating Group, that's the one that would allow it to be reduced, the median lake level to be reduced by 14 feet, effectively turning it into that wet prairie. And so we have that, and then we have another one that's a little more complicated that I didn't get into in the presentation, but it basically said that we should really only be looking at these metrics, again, not look at the most restrictive one, throw that out, but the other metrics we should only look at due to pumping that occurred in addition to that was occurring in 1957, because they said that the lakes were not being utilized prior to 1950s, and therefore we shouldn't be looking at these aesthetic and recreational things, even though the metrics are not solely recreational and aesthetic. There are more traditional ecological values to those, as I got into my presentation. And so that would have the effect of making less of a recovery needed, or in some cases not even a recovery needed, but it just needing to take care of future use. So my concern, and what I will be interested in seeing, is what happens over the next week when we find out, are they going to petition the proposed MFLs, and if so, are they going to attack the levels that we are proposing in there? So that's the only thing that, about deciding whether or not to intervene or not. There's the information that we have with the current petitions, but we also have a deadline coming up next Tuesday where we will know whether or not they intend to petition the proposed MFLs also.
And I believe the city entered into your record when it appeared a couple of weeks ago or 3 weeks ago that there was substantial activity prior to 1957, and we
Yes.
have documentation of that by historian. It's on file with Tallahassee. So that finding of fact probably shouldn't be at issue. However, it is a question of fact, and if we are limited to not being able to introduce new facts, but simply on the record on the appellate level, that sort of hamstrings us, and we might lose the kick at the cat. I'm not asking for you to agree with my statement. That is my statement. Any further comment on the issue? Vivian?
It all goes back to dollars and cents. So I'd like to, I don't know how many of you know this, but CCUA has entered into an agreement with a bottling company to allow a bottling company to be in Clay County using their water to the tune of 1.8 MGD. That is a contract. So they're concerned about money, they're selling water. And this is all legal for them to do. They're not doing anything, quote, wrong. But they have to get approval, and I think they went to Swanee River, or maybe it was their county commission, whatever, and they turned them down. Clay County Commission hasn't turned them down. So to me, this is not just picking on CCUA, because I've said publicly, and I'll say it now publicly, CCUA is ahead of the game. They have been at the forefront of water responsibility. So I give them credit for that, totally. But it's a slippery slope. And I look at the big users, and they have, example, JEA has a permit for, I don't know if it's 140, 150 million gallons a day now. I'm not sure what it is, but around that, 140 MGD, okay? They only use about 120, 125 MGD. So they have, guess what? Water to sell. And so that's the slope that we're going down. And that's a Florida issue. It's not an issue for you guys, but it's something that needs to be looked at. And so when these utilities come and start, to wah about money, they have other income coming in from selling the water. That's our water. So.
I was curious about that. I know that it's sort of a mixed bag as far as the legality of it and whether or not it should be allowed, but I'd be kind of curious to find out if the utilities are in fact selling some of their rights to raise revenue.
Well,
and you can't answer that, obviously.
I can't.
And I'm not going to put them on the
Right,
spot.
right.
But that would be something I would be interested in seeing coming out of trial.
Yeah, I think it needs to be looked at very seriously and on a bigger picture.
Yeah.
Thank you.
Thank you. All right, I think that concludes the comments. Does council have any further comments at this point? Because I have a disclosure to make. This is just for the record. Chapter 112 prohibits a person from voting on something where they have a special private gain or loss. I own property on what used to be Lake Brooklyn. Now it's all dried up. 9/10 of an acre, that's our home. We own less than 1% of the property on Lake Brooklyn. I think we clearly meet the de minimis safe harbor test, but I just want to make sure that's on the record so that you don't think I'm voting against or for my own personal gain. I think we've pretty well heard the positions of the parties. I think now it's up to council to discuss. In order to get it properly on the record and up for discussion, I'd like to entertain a motion either to intervene or not to intervene. Would somebody like to make a motion?
I'll make that motion to intervene.
Is there a second?
Second.
All right. It's now on the table for discussion. Any further discussion on the point? Mayor Lake.
I don't have any further discussion, but again, I really want to stress that I think negotiation is the best way through. It's not, I don't take lightly entering into an intervention, but I do support it, and I think it's necessary that all of us are on the same page.
Comments? Further comments? Mr. Brown, Tony Brown.
I would just, we have a problem with that now, don't we? I think it's time. We've pulled up our bootstraps for many years, and we'll continue to pull up our bootstraps as long as until this thing is resolved. And I'm not a lawyer. I agree with the mayor. I don't like litigation, but you got to do what you got to do. And if it means fighting for what we feel like is our necessities, not just for our community, but for this whole region of Florida, for water source for the future. So if our city council can be a part of that, I think we go forth.
Bobby Brown, comments?
I think our lakes, our lifestyle are worth fighting for. I remember as a kid coming over to Keystone and water up under the pavilion. It's all the businesses and stuff that profited from this, the community, the schools, everything. I'm for it.
Marion Kelly, comments?
I've lived here for 54 years, and when I first moved here, I'm on Lake Geneva. You could walk out 10 feet and swim in the lake. Now I have to go way over 1,000 feet, and you can't swim because there's weeds and lily pads every place. The water's gone.
I have comments, a couple of comments. First of all, on the mayor's comment about hopefully this doesn't go to litigation. There's a saying among trial attorneys that if something goes to litigation, the attorneys have failed. I sort of subscribe to that. I also subscribe to the notion that everything is negotiable, and I'm glad to hear that people are talking to people. It's going to get resolved. However, I think we have a duty to the public to preserve our rights, and now that it's clear that the only time we could introduce factual material would be at this level and not at the appellate level, I think we can't let this opportunity go by. I think it would be negligent in our duties to the public if we didn't intervene. So my vote will be to intervene. Any more comments?
I have a question.
Yes,
Vice
Mr.
Mayor.
Brown. Tony Brown.
In doing this puts our legal counsel, Rich will be at the table with this to represent the city?
Yeah, and that's another reason to intervene, because if we don't have somebody at the table directly. Obviously, the district kind of knows our feelings, but it's always nice to have somebody at the table to make some constructive comments. So I'm going to call the question. All in favor, say aye of the motion on the table.
Aye.
Aye.
Aye. Opposed? Motion carried, 5-0. Any further business to come before the council?
We have none.
Meeting adjourned.